Okay, with that, we jump into the key changes impacting compensation structures and actuarial valuations, and there are three main areas. The first and the biggest of all is the definition of wages. This is the biggest impact, and we'll go deep into how this is likely to impact your liabilities, your ongoing costs, and perhaps will mandate or will require changes in the compensation structure. Second is the change in the vesting criteria for contractual employees and journalists. We'll be talking about this. And last but not the least is the change in leave rules for workers. Now, this is an interesting one. Until now, the leave rules were largely governed by state laws, the Shops and Establishment Acts, but the OSH code actually defines workers and then goes into the leave aspects. We'll be talking that as well, because that also will impact your leave policies for employees which are categorized as workers. Moving on to the next slide, please. This is sort of a shortened version of on the right side in the blue of what the definition of wages is all about. And there are three pillars to this. The first pillar is that it is an inclusive definition. It starts by saying that qualifying wages mean all remuneration, whether by way of salaries, allowances, or otherwise, and includes basic dearness and retaining allowance. So we need to remember, if there is a component that is not included in this definition anywhere, and we'll talk about what the definition further says. So if it does not find a mention, it gets included in the overall remuneration. I again highlight the first pillar, all remuneration, whether by way of salaries, allowances, or otherwise, and include. So these are just an inclusions, and this is not an exhaustive list. So the compensation, components like special allowance that have existed, that exist in various compensation structures today, by default become a part of a qualifying wage. So having stated what it includes and making it inclusive, then the definition goes on to state what it does not include. Which are the things that are mentioned over here. The definition specifically excludes bonus payable under any law. We're talking about a statutory bonus here, not really the normal variable bonus, but we'll talk about the normal variable bonus in a little while. The value of any house accommodation, contribution to any pension or PF plus interest accrued. I believe contribution to NPS will also get included here. Conveyance allowance, sum paid to defray special expenses, house rent allowance, any award settlement under any court or tribunal order, overtime allowance, and commission payable to employees. Plus, there are two more exclusions: any gratuity payable and any retrenchment compensation or any other retirement benefit. So this basically is the second pillar. The first being what is included, the second pillar being what is excluded. And out of this list of exclusions that is given here, the definition clearly mentions that the ones that are marked here with the arrow, with the bracket, they cannot exceed 50%. If they exceed 50%, then the excess will also become a qualifying wage. Right? I'll reiterate the three pillars because this is the most important one. Anything that is not excluded is included. The exclusions themselves cannot be more than 50%. And, the exclusions will only have to be the ones that are listed here. Any exclusion not mentioned here is not an exclusion. It will get included. Going on to the next slide, please. Actually, go back to the previous slide. I'll just clarify one more thing. A lot of companies are reaching out to us and asking, that it is mandatory for us to restructure our compensation strategy. Well, no, the law does not require you to actually restructure. The law just defines what the qualifying wage is. If you don't restructure, then it may not be the most optimum structure that you operate with, because your qualifying wage will suddenly include all those allowances which were not considered in your gratuity calculation right now, for or even for your leave valuations. For example, a special allowance. A lot of companies have got special allowance to the extent of 25 to 30% of their monthly CTC or annual CTC. Now, until now, we were not considering this for payment of gratuity, for payment of leave, and even for PF purposes. Under the new law, under the qualifying wage definition, because it's not an exclusion, it gets included, and hence it bites. So, whilst the law does not mandate us to restructure, it becomes a necessity for us to restructure, so that we're able to balance the various aspects. We don't get a lot of hit on our liabilities, especially on the gratuity liability, which is going to come and bite. Another thing I would like to highlight here is that government is really what government is trying to do here through this definition is to widen the social security base. Right? If obviously the qualifying wage for gratuity and leave goes up, and hence perhaps what they get later on, goes up. So there's a clear intent of widening the social security base. And whilst we restructure our salaries to comply with this, we should be smart, but I mean, we should not, try to do things which goes against this objective. So we'll come back to this aspect a little later in this presentation. But for now, just requesting everyone to remember the three pillars. What's not excluded is included. So it's an inclusive definition. Only the excluded components that are there are the ones that are listed in the definition, and the exclusions cannot exceed 50%. So your qualifying wage will at least be 50%, perhaps more. Moving on. This is just the definition verbatim from the Code on Social Security. The same definition is there in the Code on Wages as well. There's only one thing that I did not mention in the previous slide, that in case there are any if there's any remuneration that is paid in kind, then up to 15% of that will also get included as wages. We can move on to the next slide, please. Now we're getting a lot of questions around various components, as to whether this is included, excluded, part of total remuneration or not. The two that very often, get questioned are bonuses and special allowances. And here we would, like to go back to, one of the landmark judgments by the Honorable Supreme Court in the case of Vivekananda Vidya Mandir, where it laid down the principles of what constitutes wages. And, the two principles that do come out of that definition was, one is the principle of universality. If any component is universally, necessarily, and ordinarily paid to all across the board, then it shall be a qualifying wage. Whatever is not payable by all concerns and may not be earned by all employees of a concern is excluded from qualifying wage. Another principle, the principle of incentives. Basically, wages exclude a component which has a direct nexus or linkage with the amount of extra output being earned by the organization. If there's no direct linkage to extra output for a component in question, the component shall be included as qualifying wage. To cut the long story short, special allowance payable monthly to employees, will that be included in the wages? In our view, yes. Whether you call it special allowance, supplementary allowance, it's a guaranteed component, it will get included. And unless you restructure, it may materially increase your qualifying wages. Bonus, some companies, we believe it can be excluded. provided it's not a guaranteed bonus. Some companies guarantee a bonus which is payable at the end of the year, and that those amounts are committed at the beginning of the year. Those will become part of wages, but till the time the bonus is actually a variable bonus and you have control over the amount of bonuses and the principles that govern the determination of bonuses, then obviously it's variable and it cannot be a wage. So those are the two very frequent questions that we are getting. The third is reimbursements. Reimbursements are not qualifying wage, and to the extent they are not anything paid to employees which are pure reimbursements and not of the nature of allowances, they can be excluded. Let me give you a classic example of LTC versus LTA, leave travel concession versus leave travel allowance. In a lot of cases, in public sector, employees are allowed to go on on LTC, and they're reimbursed for the actual expenses. In a lot of private sector companies, they include leave travel allowance as a part of the package, as a part of the CTC. And if the employee claims it during the year, it's fine. If it's not claimed at the end of the year, it's paid. The balance part is paid to the employees. In our opinion, this is an allowance, and the balance part that's paid to the employee will become part of the wage. Moving on. Okay, can I request Surbhi now to jump in and take us through the next few slides before I come back in again?
Yeah. So thank you, Khushwant. Now let's take a practical example to what Khushwant just explained. Here we have taken two examples, two scenarios to showcase what would be the new qualifying wage under the Code on Social Security. Under both the scenarios, my total remuneration remains 1 lakh rupee. Under scenario 1, we have 5 components: basic, dearness allowance, house rent allowance, conveyance allowance, and special allowance. As per the old world, which was as per the Payment of Gratuity Act 1972, the gratuity would be paid on basic plus DA, so a total of 50,000. Under the new scenario, we have to first understand what are inclusions, what are exclusions, and see whether there is a component which was not listed in either of the two, and see whether it suffices all the three principles we just discussed and becomes wage or not. So basic plus DA, explicit inclusions, hence should be a part of wage. HRA and conveyance allowance, explicit exclusions should not be a part of wage. Special allowance is regularly paid, does not have an access to extra output, hence becomes an inclusion. And under the new world, I will have a salary of 40,000 plus 10,000 plus 20,000, which would be 70,000. Under case 2, scenario 2, the explicit inclusions, basic plus DA, 40,000. Here now we are talking of a scenario where HRA and conveyance put together is 60,000. In this case, the exclusions exceed 50% of remuneration. Under the code, exclusions cannot be higher than 50%. So my qualifying wage will be 30 plus 10, 40. And to ensure that it should be at least 50%, I will have 50% as my salary for gratuity. This would be as a deemed wage. To conclude, with the same total remuneration of 1 lakh, but difference in the components that we put under the salary heads, there could be a possibility that the qualifying wage outcomes are different. Therefore, there is no single formula which could help us to define or understand that what would be the qualifying wage. each and every salary structure needs to be evaluated individually. From an actuarial perspective, the need of the hour is for the organization to engage with experts, compute code compliant wages, run multiple scenario analysis, and assess whether the resulting impact on gratuity and other long-term benefits, and how can companies absorb those impacts. So, Kushwan, moving to the next slide. Okay. Now let's see how the existing compensation structures are there for the organizations. We undertook an analysis where for few of the companies, we captured the basic plus DA ratio to the gross salary ratio. It is interesting to see, if you see the green highlighted on the pie chart, 15% of the companies are there who have basic higher than 50%. Remaining 85 companies are operating with basic to DA salary component less than 50%. This would mean majority of companies will have to redesign their structures and would see a significant impact on the liabilities for gratuity. Next slide. Okay. So here we have listed down the components which are there in the definition as per the Code on Social Security 2020. So all of these components are listed in the code very clearly. For our discussion, here we are just bifurcating for ease of understanding what goes into total remuneration and whether that component is a part of wage or excluded from wage. First three components, clear inclusions, basic, DA, and retaining allowance. So it's a part of total compensation, total remuneration, plus it's a wage also. The next few components like bonus payable under any law, statutory component, house rent accommodation, contribution to PF, conveyance allowance, any sum paid to defray, HRA, overtime, commission, all of these are clearly mentioned. Hence, these all are exclusions, but are also part of remuneration. So they are part of total remuneration, but excluded from wages. The last two components, gratuity and retrenchment compensation, they are neither total part of total remuneration nor included in the wages. Next slide.
Yeah, just one point here for the last two components. I hope I'm audible, Surabhi.
Yes, you are, Kushwan.
They're not part of total remuneration. That means these two components will not be considered for calculation of 50%.
Okay, so now next slide. Yeah. So here we first discussed all those components which were listed in the definition. Now let's see a few of the components which are majorly in our compensation structures, but the code does not mention those. How do we treat those? So here, this is the list of few of the components we have taken. As per the principles which Khushwan just discussed few slides back, the principle of universality, whether they are paid every monthly basis, routinely. Second, whether it has any nexus to extra output or it's in reimbursement nature. So keeping those three principles in mind, we will take each component and just discuss whether it should be a remuneration, whether it should be a wage or not. So first, special or supplementary allowance. From the nature, it's an inclusion, as for majority of organizations, it's universally and regularly paid. Plus, it does not have a direct nexus to output. It forms part of total remuneration and forms part of wage. Second interesting component is variable bonus. It is again, from the three principles we discussed, it's not universally and regularly payable. For majority, we see it's paid towards the end of the year or half yearly. And it does have a direct nexus between extra output or payout. It's majorly driven by an individual's performance or company performance. Hence, from those two principles, it is not a total remuneration and does not get included in wage. So from the 50% threshold, we will exclude it from there, and it does not form a part of wage. Medical reimbursement, if it's a pure reimbursement, it's not a remuneration nor a wage. Leave travel allowance, here, if it's universally paid and is not a reimbursement, then as per our understanding, it becomes a wage. All the reimbursements like books or magazines, food coupons, travel, broadband, mobile phone, if it's pure reimbursement, the nature is pure reimbursement, it is not a remuneration. And one-time payments like joining bonus or buyout of notice period, again, as it's not universally and regularly paid, it does not constitute total remuneration nor wage.
If I can just add here to what should be mentioned, some of these reimbursements, like food coupons or your broadband connection reimbursements, these can also be given as allowances as sums paid to defray special expenses, but that will be very contextual and will vary from company to company, and hence will need to be seen on the merit of the case whether they can form part of exclusion or not. Yes, Rupi.
Yeah, so moving to the next slide.